Hello, my name is Christie Arkovich. We are student loan attorneys located in Tampa, Florida. We can often assist clients throughout the United States with federal matters. That's not a difficult thing because all federal law is the same regardless of what state you live in. Even those who are out of the country. I spoke with someone today, for instance, that lives in Thailand and works remotely. But I wanted to share today the steps on how to or steps to take if you have a joint spousal consolidation. So back in the 90s, the government had this brilliant plan that a husband and wife could consolidate their student loans. And while it might sound like an easy thing and beneficial for everyone, it in fact turned out to be just a huge, colossal mess. Because what happens inevitably is people unfortunately have split up, maybe even remarried. And for purposes of IDR purposes, income-driven plans, you had four incomes to look at. Also, for those with public service, you could not obtain the benefits of public service and still cannot because you are required to have a direct loan, and these loans are the older FFEL loans. And what that means is federal family education loans. So the government back in October of last year, 2022, entered an act that basically allows folks to separate these loans, to now have your own loan under your name, and to recognize divorce decrees and things like that, so that you don't have that joint 100% jointly and severally liable for each other's student loans. And so it's very clear on what the steps are now to take to start that process and what to expect. And so step number one, you want to file an ombudsman complaint. You basically need to give the ombudsman office, and that is an office of the Department of Education. You want to give them notice of your intent to separate. Now, I know the application is not yet available, but they want to make a list of everyone who potentially wants to separate their loans. Some people don't want to. Maybe some people have already paid off their loans also. So they're going to be focused on those that want the relief. And so there's two ways that you can notify the ombudsman office of this. The first is you can go on the website that they have, and you can fill out or initiate a case. It's called a complaint. I like to call it an inquiry, but the website actually says complaint. And that's located at studentaid.gov/feedback-center/. So that's studentaid.gov/feedback-center/. That's also available on our blog, a link for that. You alternatively could email their office at jointconsolidation@ed.gov. That's jointconsolidation@ed.gov. And you're basically giving them notice of your intent that you want to separate these loans. Step number two, you want a forbearance. You want to have no payments during this process, right? So you have to notify your servicer of your federal loans that you want a forbearance. The forbearance is going to last the duration until your loans are addressed in this separation process. So it's not a 1 month or 2 month process. It's expected to take till sometime in 2024. But this way you have a forbearance and you don't have any payment or any documents that are due. You want to contact your servicer for that forbearance. Now, will the forbearance count towards IDR purposes? Yes, it will. So that means that as you're accruing time under income driven, you get to count this time period that you're waiting for the application to be available. Now, only one borrower needs to call for the forbearance. So you don't need to have you and your ex do that. Both borrowers have to apply for the separation unless one of the borrowers certifies that they were abused in some fashion. That might be physical, might be emotional, might be financial, or that borrower does not have access to the financial information of the other borrower. So again, in order to get the relief, the application, when it's available, the way that works is that you have to have both borrowers sign the application, or one borrower certifies that they either were abused in some fashion or they don't have access to the other's financial information. There's no document or police report or anything that needs to be filed. You just have to self-certify that, yes, I don't have access to the other person's information or I've been abused. And that's all you need to do. The Department of Ed gladly wants to separate these loans. They will basically get them back into repayment. A lot of folks are not paying on their student loans, their joint consolidated student loans. They feel that why should they pay for this other person who might be in jail, might be whatever, no contact whatsoever. I get that. And so does the Department of Ed. And so they are, I think, erring on the side of they're not going to back check this certification. They want these loans separated too. And then they're going to go back and figure out whose loans were whose and try to separate them. There is a period of time for the other borrower to object. So they will be notified. How they'll be notified will be based on whatever contact information the Department of Ed has for them, their last known address, their forwarding address, their email, their phone, whatever it is. And they'll have a 30-day period to object if they think that the split is unfair. You'll have an opportunity to send in any divorce decree that might say, well, my spouse was to take, all the student loan debt or whatever it is. And the Department of Ed, we understand, will abide by those divorce decrees. So this is important. If you are undergoing a family law matter, be sure to have in the stipulation or decree or whatever document ends the marital unit to go ahead and make sure that you designate who takes the student loan, because that's an opportunity to maybe tell the Department of Ed what's going to occur with these student loans, and they'll abide by that, which is something they've never done in the past. The Department of Ed does not care in the past who got divorced and who was to take on the debt. Their position was always each borrower owes 100% of the liability of both loans, of both people. And so that's a huge adjustment, and they want to do that. I think that's about it. And so remember, you get IDR credit. There is a two-step process. You need to notify them of your intent. That gets you on a list. You need to, and that's the Ombudsman Office with the forbearance. You need to notify your servicer that you want a forbearance. And then since you're on that list, you'll get an email application when that becomes available. They're still creating it. It has a number of different steps. We don't know exactly what it's going to look like. We will have subsequent videos as we learn more information, but we're very, very happy that the Department of Ed has taken steps now to separate these joint spousal loans. We've done our own work on separating those loans in bankruptcy court, and it can get messy. So we're really happy that they're doing this. It is taking a long time, but we appreciate the nuances that are involved and so forth. So I hope this video has been helpful. If you would like to do a strategy session with us, we can be reached at info@ChristieArkovich.com. Our office number is 813-258-2808. We often will walk folks through whatever it is they need to do during the strategy session. And then lastly, please subscribe if you think this video has been helpful to you. It helps us track what we want to talk about, what we think people want to know, and other things like that. So have a great day. Thank you very much.